titled Evolving Challenges and Opportunities in International Law. The keynote address of this session will be presented by His Excellency Judge Raul Pangalangan, an esteemed former judge of the International Criminal Court. I would like to request His Excellency Judge Raul, who will be joining us online, to please kindly deliver his keynote address. Thank you. I request the audience to please settle down. Thank you. I apologize, we're just experiencing a slight delay. The judge will be with us online shortly.
International security. We'll actually have a session on the evolving challenges and opportunities in international law. And for this, I congratulate, again, the organizers, because they have chosen to address the conundrum on whether it is worthwhile to have peace without justice, and whether peace is all about power and politics and not about law. I am delighted that our speakers today include my friend Professor Hurst Hanum of Tufts University and Professor James Kraska, who has actually taught at the University of the Philippines as well. When the organizers formulated this topic, I don't know if they had imagined that we will be discussing the theme of this session under the shadow of the biggest challenge to international law and its prohibition on the use of force. The Russian invasion of Ukraine is the unabashed invasion of one sovereign against another, with the thinnest veneer of legality. It fundamentally undermines the foundations of the post-World War II legal order, founded on the prohibition of the use of force against the territorial integrity and political independence of states. This is not to say that international law has not been strained and stretched to legitimize the use of armed aggression in the past, times when many of the international legal community looked the other way. But this invasion is the most brazen violation of the norms of the post-World War II consensus. It is an in-your-face challenge to that legal order, as if to ask, what do you plan to do about it? We can actually look at the bright side of things. One is the quick responses by both the ICJ and the ICC. Courts are known for having their glacial responses to crisis. But this time around, both courts moved with unusual dispatch, responding, in fact, within days of the Russian invasion of February 24, 2002. And it was actually impressive that both the ICJ and the ICC prosecutor were able to keep us posted with the actions they were taking and concrete steps they were taking to address the issue. But on the other hand, it is also useful for us to look at the limits of international law, of the international law responses to the crisis. For the ICJ, notice how it exercised its jurisdiction. it was under the compromissory clause of the Genocide Convention, and Ukraine ended up asking for a rather unusual relief, not asking the court to say that the other party committed a violation, but asking the court to say, please confirm that we ourselves have not committed any violation. Compare that also to the ICJ's response to the cases filed by Yugoslavia against the individual member NATO states that took part in the bombing in Kosovo. And notice the way the court basically avoided jurisdiction with proper legal justifications, but still a stark contrast to its response today. The ICC as well has its own jurisdictional limits. Notice that the prosecutor's statement said from the very beginning it will find jurisdiction over war crimes and crimes against humanity, but not over the crime of aggressive war. And the problem of fair labeling of the charges is nothing new, but it is rather persistent. The court faced it in the case of the Rohingya in Myanmar, where the court did not have jurisdiction over Myanmar, but it had jurisdiction over Bangladesh, and exercised jurisdiction not over the crime of genocide, but over the crime of forcible eviction. But this is not the first time that there is a gap between peace and justice, and I would like to close with this point. Even if you look at Nuremberg and the Tokyo War Crimes Tribunal, today these proceedings are remembered for what we will today call the crimes against humanity that were committed during World War II. But if you look at the decision, the decisions of these two tribunals were mainly about the crime of aggressive war. So even that showed the limits of those tribunals addressing a historical tragedy. Indeed, the Tokyo War Crimes Tribunal completely ignored the comfort women situation, which was brought to the attention of that tribunal. And even if we look at the principle of command responsibility, which, by the way, was first adjudicated in the Philippines in the Yamashita case, if one looks at the shortcomings, both procedural and substantive, and one looks at what was codified in the Rome Statute, what we see today codified in the law is actually the dissenting principles in the Yamashita case. By way of closing, the forum is most timely. We have gathered a very strong panel of speakers to address the issues addressed to us by the organizers, to explore the robust rule-based international legal order and the role of international law in identifying and providing solutions for these security changes. I look forward to the very interesting presentations by the strong panel of speakers that the organizers have gathered. Thank you.
Thank you, Your Excellency, Judge Raul Pangalangan, for taking out valuable time for your keynote address. We now begin the panel discussion of this session. This session builds on the understanding that a robust, rule-based international order is required for moderating state behavior and tackling new, non-traditional security challenges. However, the international legal obligations and global governance system based on international law principles are often criticized for being in favor of powerful states. The session aims to identify the role of international law in providing solutions for global security challenges, including that of cyber operations and warfare, international investment arbitration and economic security of developing states, changing nature of armed conflict, and the role of international institutions. This panel discussion will be moderated by Mr. Owais Anwar, lawyer and director of Research Society of International Law. I would like to request Mr. Owais Anwar to please come on stage and convene the session. I would also like to request the esteemed panelists of this session to please come on stage. Mr. Toby Landau, Dr. Kubo Machak, Mr. Ahmed Irfan. I also welcome the esteemed panelists of this session joining us virtually, Dr. Hurst Hannum, Dr. James Kraska, and Dr. Dane Azaria. I hand over the session to you, Mr. Hurst.
Thank you very much, Hira. Bismillahirrahmanirrahim. Excellency Judge Raul Pangalagan, honorable guests, ladies and gentlemen, it is indeed a pleasure to be moderating this session on global security challenges and opportunities in international law. I'm particularly grateful to the organizers, the National Security Division, Dr. Muid Yusuf, and certainly Dr. Sadia Zahoor, for dedicating an entire session to international law. Unfortunately, many of us know that this is not an area that has received the kind of attention it deserves in Pakistan, and so I'm grateful to the organizers for making this part of this. Today we have with us an exceptional panel of experts who will be discussing subjects as diverse as self-determination and human rights, cyber warfare, maritime security law, state silence and its impact on the development of law, and international arbitration. The format of the session will be an hour of moderated discussion, followed by about 20 minutes of questioning from the audience to our panel. Now, without much further ado, allow me to introduce to you our panel. I'm delighted to have with us online Professor Hurst Hannum, who is Professor Emeritus of International Law at the Fletcher School of Law and Diplomacy, Tufts University. He has also served as a Sir Y.K. Pao Professor of Public Law at the University of Hong Kong and is Professor of International Law at the Central European University in Budapest. Professor Hannum's focus is human rights and its role in the international legal and political order, including issues such as self-determination, minority rights, and conflict resolution. Welcome to the panel, Professor Hannum. Also joining us from the United States is Professor James Kraska. Professor Kraska is Charles H. Stockton Professor of International Maritime Law and Chair of the Stockton Center for International Law at the U.S. Naval War College. He is also Visiting Professor of Law and John Harvey Gregory Lecturer on World Organization at Harvard Law School and Visiting Professor of Law at Reading University. Thank you very much, Professor Kraska, for joining us. We also have with us Dr. Dane Azaria. Dr. Azaria is an Associate Professor at the Faculty of Law, University College London, and Director of the State Silence Project funded by a grant of the EU's European Research Council. She is also a laureate of the prestigious Guggenheim Prize in Public International Law, the book reviews editor of the British Yearbook of International Law, co-rapporteur of the International Law Association's Committee on Submarine Pipelines and Cables, and member of the ILA Committee on the Use of Force by Invitation. Welcome, Dr. Azaria. I'm pleased to have with us in the auditorium Dr. Kubo Machak. Dr. Machak is a legal advisor at the International Committee of the Red Cross in Geneva. Prior to joining the ICRC in 2019, he worked as an associate professor of public international law at the University of Exeter. Dr. Machak is the author of the book Internationalized Armed Conflicts in International Law and the general editor of a very interesting project, the Cyber Law Toolkit, an interactive online resource on the international law of cyber operations. We are also fortunate to have with us Mr. Toby Landau, QC. Mr. Landau is a barrister, advocate, and arbitrator, and a member of the bars of England and Wales, Singapore, New York, the British Virgin Islands, and Northern Ireland, and is also registered in the DFIC. He practices in London as a sole practitioner and in Singapore from Duxton Hill Chambers. As counsel, he has had a broad commercial and international practice in London since 1994 and in Singapore since 2017. He's argued hundreds of major international commercial, investor state, and interstate arbitrations, as well as groundbreaking cases in the highest courts of England, Singapore, Hong Kong, Pakistan, and the Caribbean. Welcome, Mr. Landau. And last but certainly not least, we have our very own Mr. Ahmed Irfan Aslam. Mr. Aslam heads the International Disputes Unit at the Office of the Attorney General for Pakistan. He was also partner at Salahuddin Saif and Aslam and has previously served as a legal advisor to the government of Pakistan on trade and investment laws. Mr. Aslam has argued numerous cases representing Pakistan at various international fora and has also served as an arbitrator internationally. Mr. Aslam is a recipient of the prestigious Sitara Imtiaz for public service for representing Pakistan and negotiating in the Karki arbitration. He was also instrumental in Pakistan's negotiations with an international firm to settle the Recodec issue. Mr. Ahmed Irfan Saab, thank you very much for joining us. Now, I will go back to my seat and we can commence. So I would like to begin, Professor Hanum, with you. And this is a question that is something that really, Pakistanis ask quite a bit when it comes to international law, and it relates to self-determination. Some have argued that self-determination has radically changed or significantly evolved after 9/11. What do you feel is the status of this right in relation to the decades-old dispute of Kashmir, Jammu and Kashmir, as well as the more recent situation in Ukraine?
I'm glad that you began with such an easy question. First, I want to thank the organizers of the dialogue, and I'm very sorry I couldn't actually be in Islamabad, but at least we have the opportunity of speaking virtually. The right to self-determination is probably one of the most widely accepted in international law, at least in theory. The problem is that its interpretation has become either so flexible or so hypocritical that it no longer serves very much of a real purpose. If we go back to the beginning, self-determination meant something very, very narrow, which many non-lawyers don't realize, and that is simply that the colonies of European powers had the right to become independent from their colonizers. That has been achieved almost entirely, but even that narrow definition is much less concrete than it was before. While everyone, for example, continues rightly to speak of the right of Palestinians to self-determination and independence, very few people speak at the same time of the right of Western Sahara to independence from Morocco. And so even former colonies no longer enjoy the right that everyone thought they had back in the 1960s and 70s. It's also the case that self-determination does not include, and never has included, although some have argued for it, any right of groups within states, identified by ethnicity or language or religion, to become independent. In other words, to secede. This is, for better or worse, exemplified by the attitude of both India and Pakistan towards the conflict in Kashmir, which has never been about self-determination for the Kashmiri people, but rather has been treated as a boundary dispute by the two countries, with the only options that they would consider being integration into Pakistan, integration into India, or some sort of division, which is the de facto situation now. Too often forgotten is one more aspect of self-determination, and that is the right of independent states to in fact be independent. And here I would simply reiterate what Judge Panalangan has said about the invasion of Ukraine by Russia. This is obviously a violation of Ukrainian sovereignty, but it's also a violation of Ukrainians' right to self-determination. Self-determination is not a very useful tool, in my view, for the policy of almost any state these days. Because, as I say, it tends to be interpreted in such a way as to justify whatever the state wants to do in any event, rather than being seen as a norm of international law that provides much guidance to the way states should behave. I'll stop there because I'm used to giving a course in which I get to talk for 2 hours every week on self-determination, and I could go on much longer.
No, I appreciate that, Professor Hanum. My follow-up question to that, and I think this leads to a slightly wider argument on human rights, and I want to quote your book, and it's an excellent book, by the way. When I was preparing for this session, I picked it up, and honestly, I can't put it down, though I've just started it. Rescuing Human Rights, a Radically Moderate Approach, which I have just started reading, and you note, I think, the first line of your preface is, human rights are in danger of becoming the victims of their own success. And later, I think it's chapter 1, where you note academics and pundits now reflect on the limits, twilight, or end times of human rights, the demise of the last utopia, and the more generous right about human rights being at a crossroads or in crisis. Professor Hannum, is the international human rights regime in crisis? And what approaches can we take to prevent this?
It's a short book, but I'll try to summarize some of the major points. I don't think that human rights are in crisis necessarily, but I think there is a danger that the advances that have been made over the past several decades by people and members of civil society, even if not always by governments, do run a risk of being lost in the past. This is in part because of events beyond anyone's control. Things like the COVID virus, things like the financial crisis in 2008, which suddenly made life much more difficult for people everywhere in the world. It's also been more difficult by the flukes of politics and power. We happen to have had over the past decade in particular, Trump in my own country, Orban in Hungary, Mr. Duterte in the Philippines, and of course Xi Jinping in China and Putin in Russia. These authoritarian governments, not surprisingly, have pushed back on human rights. And they're pushing back much more loudly now that there are more of them. The book, in a sense, is aimed at those who are human rights advocates, because they too don't own the primary responsibility for the difficulties faced by human rights, but they do, in my view, share some of the blame. And that is that following the end of the Cold War, and we saw for a decade in the 1990s the assertion of US and Western power in ways that were often illegal, as in the bombing of Kosovo and the invasion of Iraq. But more importantly, the triumphalism that many of my colleagues in the human rights movement felt, that human rights were finally taking over the world, was accompanied by a feeling that all we had to do was invade a few more countries, give a few more hundreds of millions of dollars to aid democracy, and that the world would be the same and it would all look like Sweden. I apologize to Sweden for using them as the example of the perfect country, but I do it all the time in class, and they're as good as any, I suppose. And I think what happened is that people expected too much from human rights. They thought that human rights included democracy, that it included wise leaders who were not corrupt or interested only in power, that it included looking like Sweden or the United States or other Western countries, when in fact human rights does none of these things. Human rights, to me, provides the context in which progress can be made. It's not about changing societies. It's not making every country in the world look the same. And as a result, the combination of the assertion of the United States and the desires of many with whom I would agree in the West to promote issues that were somewhat tangential to human rights led to a backlash. This fed into, in some cases, the rise of the authoritarians that I mentioned earlier. And so I think in going forward, we need to return to the understanding of human rights as defining the relationship between citizens and their governments, of giving rights to citizens and assigning obligations to governments. There are many countries in the world, unfortunately, most of them in the West, who have accepted the full range of human rights. But even its greatest promoter, the United States, continues to reject the notion that economic, social, and cultural rights have any relevance. While in China, they pretend to care about economic and social rights and to ignore the political and civil rights that make any sort of change possible. Human rights still has tremendous potential, but I think we have to also recognize its limits. And if we don't, if we continue to add human rights to everything, if we continue to confuse it with international accountability and stopping wars perfectly possible to respect human rights and engage in a war. But we focus on the big issues where tens, if not hundreds of thousands of people are being killed. And we've forgotten, I think, the day-to-day work that needs to take place in every country in the world, domestically as well as internationally, to address the violations of unfair trials and insufficient housing and restrictions on freedom of the press that most people suffer. Most people, fortunately, in the world are not suffering from armed conflicts. Human rights don't work well in war, although they're still relevant. But I think our focus on wars, both to protect human rights and also to violate them, needs to be shifted, and human rights need to return where they began, which is working to make societies more equal, more fair, more participatory, and over the long run to allow them to develop their own culture and their own principles in ways that respect human rights, but that also can respect the history of the countries concerned. I apologize for the somewhat long answer, but even at 150 pages or so, the book is too long to squash in 5 minutes. But thank you very much.
No, absolutely. Thank you very much, Professor Hannum. Dr. Maciek, I want to move on to you for the next question. It's only recently that the world is waking up to the impact of, say, cyber operations and cyber warfare, and how pervasive its impact can be on societies and modern warfare itself. Could you help us better understand what you feel is the impact of cyber operations today on modern warfare, and how international humanitarian law, which is the law of armed conflict, aims to regulate this?
Yes, thank you, Oves, and thank you also for the kind introduction, and thank you to the organizers for the invitation. I am based in Geneva with the International Committee of the Red Cross. So, when I was told by the organizers, but be prepared, it's a slightly warm spring in Islamabad, I didn't exactly know what I was coming in for. So it's very pleasant weather here, and I'm really enjoying my stay, and I'll be happy to cover the aspects that you ask about. I think there are three main pieces to this puzzle, and so the first piece is the humanitarian puzzle. So for all of us, when we think about maybe we have a close relative, someone who would be expecting to go for a surgery to a hospital, and if they came to the hospital and they would be turned away because they would be told that there is a cyber attack that makes the hospital systems not function, we would perceive this as a certain human cost. Maybe then we would come back home and we would find out that there are news saying that reportedly the water supply quality cannot be guaranteed because there was a cyber attack against the water supply system, against the water purification station. And maybe when we want to then communicate with our loved ones and tell them about what's going on, the power grid goes off and the communication systems are not functioning. And you might be thinking, oh, this is all cyber Armageddon, like what he's talking about. But actually, the only fiction in this is combining these incidents into one, because they're all based on actual cyber incidents that have happened. Some of them in peacetime and some of them in time of armed conflict where IHL applies. So, the first piece of the puzzle is the humanitarian puzzle, is the understanding of the human cost that cyber operations can have. And it's something that for the ICRC is particularly important, and we have been talking about that for quite some time. But as of recently, it's also something that states are taking very seriously as well. So it doesn't just come from us, but for example, last year, in a multilateral process called the UN Open-Ended Working Group, in which Pakistan is also an active member, all states participating in that group agreed that cyber operations against critical civilian infrastructure, like the examples that I have just mentioned, can have, and this is a quote, potentially devastating humanitarian consequences. So that's the first piece of the puzzle, to understand the humanitarian aspects. Then the second piece is, what you hinted at when we talk about warfare. It's of course the military aspect. And if you look around the world, we see a very volatile world. We see a world that's affected by armed conflict. At the ICRC, we do our internal classification of situations of violence around the world, and we are tracking over 100 armed conflicts around the world. And about a third of states, as of 2021, were involved in one way or another in some of these armed conflicts. So that's one factoid, that's one statistic. The other statistic is that according to various studies, either dozens or even over 100 states in the world are developing military cyber capabilities. So, when you think about the use of military cyber, this is no longer science fiction. This is something that states are developing. Some of them say it openly that they do, and some of them even say openly that they have used military cyber capabilities in ongoing armed conflicts. And so there are at least 4 states that have made such express acknowledgements. So this is the second piece of the puzzle, is to understand the military aspect and, at the intersection of those 2 trends, if this is something that is happening during armed conflicts and it can have these potentially devastating humanitarian consequences. In the third step, we need to understand, well, what are the limits on such behavior? And so that's the legal, and that's the third piece of the puzzle. And, the good news is, let's start with the good news. So the good news is that states agree that whatever is happening right now in these contexts does not occur in a legal vacuum. So there is a general acknowledgement that international law applies in cyberspace, and as of last year in another multilateral process, the so-called Group of Governmental Experts, the GGE, the representatives of states, and then this was endorsed by a United Nations General Assembly resolution, so you could say it's a degree of consensus in the international community, also referred to the applicability of international humanitarian law in the cyber context. So we now have a broad agreement that cyber operations during armed conflicts do not occur in a legal vacuum, but they are subject to the constraints in IHL. And so another part of the good news is that some of the rules are very clear. I started by talking about hospitals, cyber operations against hospitals. So under IHL, it's quite clear that there is an obligation to respect and to protect medical facilities in time of armed conflict. Okay, so that's quite a comprehensive obligation, and you can quite easily interpret it to cover all sorts of hostile cyber operations. Because how can you interfere with the functioning of a hospital and still say that you are respecting and protecting the medical facility? So some things are quite clear. But now for let's not call it bad news, let's call it work in progress. So the work in progress is that there are still unsettled questions of interpretation of international law. And today we don't have too much time to go into detail on all of them, so let me just give you one example that's been keeping us busy. So, we're all living in a very data-driven world. I think you will all agree. And it turns out that such a fundamental aspect of cyberspace as data does not have a settled status in the sense of settled legal status under international humanitarian law. So there is a debate whether data constitutes an object. And that sounds very academic. And in my previous life, before joining the ICRC, I was a professor of international law. So I enjoyed these theoretical discussions. But actually, this has a very, very practical repercussions. Because under IHL, we have a fundamental prohibition, and that's the prohibition of direct attacks against civilian objects. So notice the word objects. Right? So we need to understand what constitutes an object. And the problem is that if we read the notion of objects too narrowly, thus excluding data sets, which would then exclude essential civilian data sets, like social security data, like taxation data that our societies depend on, then the risk is that this would create a protection gap, and as a result, considerable humanitarian consequences. So that's why we need this work on interpreting these rules, and that's something that we've been engaged in quite closely. I hope that answers the question.
Absolutely, that was very, very helpful. Dr. Maciek, as a follow-up to that, I wanted to ask, how do you see something like cyber warfare or cyber operations being regulated by the international community? I mean, in your opinion, what are the specific maybe areas that you feel need to be regulated better in this regard?
Okay, so the data question is certainly one of the examples, but I think to understand how they need to be regulated, we again have to have a look at the evolution, how we got to the point where we are. So the answer to your question has, I think, 3 parts: to look at the past, at the present, and at the future of international regulation.
Absolutely.
And so in the past, what we have seen were some attempts by states from all sides of the world proposing, what has been referred to as a global cyber convention or a global cyber treaty. And despite various efforts, these efforts haven't gone very far. So in the lack of success by states to agree on such a global new treaty, what has filled the space were various non-state-driven initiatives, like expert-driven initiatives that looked at how international law applies in the cyber context. And that's not just in situations of armed conflict, but more globally. And so one of them to highlight is the Tallinn Manual on International Law Applicable to Cyber Operations, which is a key reference point, but it's still, a non-binding document produced by a group of academics. So it's a very important piece of work that helps our understanding, but it's still, a non-binding compilation. At the ICRC, we have also done our our part in this work in the past. So we have produced reports on the human cost of cyber operations that provides much more detail on what I have already mentioned. Then on how states can actually avoid civilian harm, or at least reduce civilian harm of military cyber operations. And we also produced position papers that look at how IHL applies to cyber operations. So that's some of the important work that has happened in the past. Now, in the present, we have discussions going on at the global, at the regional, and also at the national levels. At the global level, there's the open-ended working group that I have mentioned, which is where a lot of the multilateral global discussion is being concentrated. And so this group is going to continue its work for the next 4 years, so it's probably too early to say where it will get with the regulatory prospects. Another aspect at the regional level, the Organization of American States or the Asian African Legal Consultative Organization, of which Pakistan is a member, also have their own initiatives that look at how international law applies in cyberspace. So it might be that some new regulation will come out from these efforts. But by and large, the bulk of the work in understanding how international law, including IHL, applies to cyber operations, actually comes at the national level. And so a number of states, and again from all sides of the world, but for now predominantly in the West, but not only, have come out with their national views, national positions on how international law applies in cyberspace. And so this is something where we see great prospects in the future, and it's exactly, on questions like data, or there's another important debate in international humanitarian law, and that's the interpretation of the notion of attack under IHL. And so it's on questions like that states should be encouraged to come out with their national positions. And I would just add, the sooner you do this, the better, because those states that are already out there with their views also play to some degree a part in influencing others, because their views are there that others can learn from. And as you mentioned, the Cyber Law Toolkit project that we have at the ICRC, so one of the things that it does is it tracks all of these national positions. So if you want to have a look at which such positions exist, you can go to that project, just Google Cyber Law Toolkit, and you can see them discussed in detail. And so that brings me to the future. So what will we see in the future? We have the Outer Space Treaty of 1967. We have the Law of the Sea Convention of 1982. Are we going to have a cyberspace treaty of 2025, of 2030? I think it's too early to tell. And I think from the IHL perspective, which is the perspective of the International Committee of the Red Cross, what matters is where exactly will state views on these complicated questions, how we interpret the notion of objects, how we interpret the notion of attacks, these unsettled questions. So where exactly will state views coalesce around? If they coalesce around protective interpretations, such as essential data sets are protected, or when it comes to attack, the loss of functionality falls under the notion of attack, and thus a cyber operation against a banking network that brings it down but doesn't cause physical damage is also considered as an attack and thus prohibited under IHL, and so on. And so if these protective views are endorsed by states, then perhaps we don't have a need for new regulation. And if not, and if there is a gap in protection, then we might need to think about new rules, and it might be the ICRC's role to contribute to proposing such rules, but I think we are not at that stage yet.
Brilliant. Thank you so much, Dr. Maciek. Staying on the subject of the development of international law, Dr. Azaria, I wanted to bring you in here. You're leading a very fascinating project on state silence. And to a layman, it would seem somewhat counterintuitive that a state can be legally bound by simply omitting to do something or failure to act or silence, really. And yet this is a feature of international law. Could you help us understand the conditions under which a state's silence may amount to acceptance of the law?
Thank you very much.
Can you hear me? I hope that you can.
Yes, we can.
Thank you very much for the invitation, and thank you very much for your questions. Perhaps I would like to very briefly connect my comments to the previous speaker, and I'm really sorry I wasn't able to be present there. Indeed, in cyberspace, there are two issues with silence implicit in my colleagues' remarks. The first one is empirical, that of course the more states do not take the lead in the evolution of the law, of whether international law applies and how it applies to cyberspace, that means that they leave a gap that is filled by non-state actors. And that's much more empirical, but in relation to how state silence can be legally relevant as acquiescence, I think the comment that there are some movers and makers in international law by states that are much more familiar with cyberspace or issues that concern them in cyberspace, they will lead the debate about where international law should go in this field, and those states that remain silent are likely then to contribute to the development of international law, but towards the development that the leaders are taking it. So allow me to simply say that, to start by saying that legally relevant state silence in the sense of acquiescence, it permeates the whole of international law. So it is relevant in relation to sovereign title, territorial maritime boundary delimitation, but crucially, acquiescence is relevant for the identification of customary international law, but also the formation, interpretation, and the modification of international agreements. And because it is relevant in the sources of international law, it affects all primary rules of international law, from the law of the sea, that James will be touching later, to international trade law, even investment law, but also the prohibition of the use of force and so on and so forth. So state silence as acquiescence goes to the heart of legal security and stability in legal relations across international law. But allow me to give perhaps some context from the field of the prohibition of use of force, which is of particular importance for our panel. And there the question arises as to the development of CASTA and the interpretation of the Charter of the United Nations over time regarding the exceptions to the prohibition of use of force. So as it stands, the UN Charter prohibits the use of force with two express exceptions: individual and collective self-defense if an armed attack occurs pursuant to Article 51 of the Charter, and the authorization of the United Nations Security Council acting under Chapter 7. Now, some states, including the United States, have argued, especially in the past 2 decades, that the Charter permits an interpretation that the use of force against non-state actors in another state's territory is permitted under Article 51 of the Charter. And other states, as the United Kingdom, have argued that custom now permits the use of force on the basis, on the ground of humanitarian intervention. Now, the silence of other states becomes crucial here for determining whether opinio juris, acceptance as law in relation to custom identification, and for identifying whether there is a subsequent agreement of all treaty parties in relation to the interpretation of the Charter, the UN Charter. Now, the International Law Commission, and you have asked me what are these conditions under which silence can become legally relevant. The International Law Commission, in its 2018 conclusions on identification of custom and its 2018 conclusions on subsequent agreements and practice in relation to the interpretation of treaties, has recognized the relevance of state silence, and more specifically, the Commission has stated that failure to react over time to a practice may serve as acceptance as law, as opinio juris, in other words, provided that states were in a position to react and the circumstances called for some reaction. It also has stated that silence on the part of one or more parties may constitute acceptance of subsequent practice of other treaty parties, again, when the circumstances call for some reaction. So I suppose the important question that comes next is, what are specifically these conditions? Because of course they're not absolutely clear in international law, and I think these are the issues that as international lawyers and of course as states representatives, we should be considering, given that we have new realities in international law today. We have more than 190 states. Communications are easier. International law today protects not only bilateral interests, but also community interests. And of course, international organization exists and provide permanent fora of communication between states.
Absolutely. Dr. Azari, just a follow-up question on this. You had mentioned territorial and maritime boundaries. Could an agreement for, say, a permanent territorial or maritime boundary ever be made simply by acceptance in silence or by acquiescence, as you've discussed?
Thank you. This is a very good question. Of course, it goes both to acquiescence for title, delimitation, but also even in relation to custom and treaty interpretation. I don't think that any court or tribunal has ever accepted simply on its own acquiescence by silence without anything else. Of course, we're talking about silence that is qualified against the circumstances in a particular, the objective circumstances surrounding that silence, and in any event, the International Court of Justice had done so under very strict conditions, very high threshold on both in relation to issues of boundaries, but also in relation to custom. So allow me perhaps to indicate to you the circumstances that we really, to explain to you rather how strict these conditions are. And so in fact, I think that the International Court of Justice in its latest decision, Somalia versus Kenya, where it examined the existence of a tacit agreement or acquiescence for the purpose of establishing whether there was an agreement for maritime delimitation between these two disputing parties. The court has established thresholds that are extremely high, and I think it's almost impossible to meet in a practice. The first one is that there have to be circumstances that call for a state's reaction. Now, this is a behavioral norm. We're not talking about an obligation to react. And the behavioral norm that now here is that a state's interests are under threat. That state would normally protest. It would say no. But I suppose, again, the court what has done is to say that these circumstances exist when the other state has made a clear and consistent legal claim in order for the silent state to be expected to react. Mm-hmm. So we need very clear and consistent legal claim over time. In addition to this, we need knowledge. Now, the court, the International Court of Justice and other courts have not clarified whether we need real, actual knowledge, or whether instead we, construed knowledge is sufficient. In the fisheries case, it seems that the court has accepted construed knowledge. Of course, if we try to transpose the issue of construed knowledge outside maritime delimitation and we transpose it into custom identification, for instance, and more sources, norm creation processes, that can become particularly challenging for states. Again, as I said, because of the means of communication that have changed. But at least in the context of a bilateral relation on maritime delimitation, direct exchange of notes, discussion between states, these will establish the threshold of knowledge. And the third requirement, extremely important, is that a state has to have the capacity to react. Now, international courts and tribunals, especially in the cases of maritime boundary delimitation or territorial title issues, have really looked at capacity to react, or rather incapacity to react, and have connected it to situations of armed conflict. When a state has been involved in an armed conflict or an internal armed conflict, civil war, there is a presumption that it lacked at the time capacity to react. But I think that we ought to consider something bigger here that international courts and tribunals have not as yet dealt with. The International Law Commission has not addressed either, but has not excluded it either. We accept in international law that states are equal, and that is the law. But in reality, states differ in terms of their economic and institutional capacities. They do not necessarily have the same a number of legal advisors in capital, but also in their missions abroad, especially in international organizations such as the United Nations. And that really affects their capacity to react to claims made by other states, especially in international fora, such as international conferences and international organizations. And I think that this is something that the law about acquiescence should take into account to some extent. We should have some legislative responsibility for states. That should come as part of just being a state. The moment one is a state, they have international legislative responsibility, but there may be some leeway for arguing that there must be some differentiated legislative responsibility.
Absolutely. Thank you very much, Dr. Zari, for that. Professor Kraska, I wanted to come to you. We're celebrating the 40th anniversary of the UN Convention on the Law of the Sea. This was adopted and signed in 1982. 15 years worth of negotiations went into it. But the world has significantly changed since then. I mean, just since the 80s, we've seen novel challenges to the international maritime legal regime and the maritime security regime. How do you think UNCLOS is still relevant today? Please.
Thank you very much for the question, and thank you to the Islamabad Security Dialogue for the invitation to share a couple of thoughts about the law of the sea. I would suggest that the law of the sea, the UN Convention on the Law of the Sea, yes, it had this formal negotiating period, but there's really about 500 years of normative development of the convention that is, I would suggest, the second most important treaty in existence after the UN Charter, because of course it applies to 70% of the globe, and it provides a stability of expectations for coastal states, port states, and flag states, and of course even landlocked states. And so I think it is continuing to be even more relevant, and that's the nature of the flexible nature of the convention. It was the first treaty to manage a global resource, seabed minerals. It's also linked to other important equities of states, including ultimately the health of our global ecosystem and climate change. And it does this through an adaptability, because it's a framework or a constitution for the oceans. It recognizes that there are numerous other conventions and treaties that plug into it, some of these even predating the Law of the Sea Convention itself. And just the IMO, for example, has cognizance over some 50 agreements and some 150 codes and guidelines that apply. This just is in terms of regulating international shipping. And of course there are other agencies and components of the UN system that have a great overlay with the Law of the Sea Convention, such as the Food and Agricultural Organization, the International Labor Organization with protection of seafarers, the UN Environment Program, the International Telegraphic Union, Telecommunications Union, and others. And so the Law of the Sea Convention is not simply the doctrinal rules that are within the four corners of the document, but under Article 293, courts that are sitting in review of issues under the law of the sea can incorporate these other external sources of international law. It might be in the future the UN framework on climate change, for example. In addition, the Law of the Sea Convention itself has 2 implementing agreements that are more important today than ever. The first is the Straddling Stocks, or the High Seas Fish Stocks Agreement, and this helps to solve the problem and develop the law within how do you manage stocks that are inside and outside of the exclusive economic zone. They go from the high seas to the EEZ and back. And even that implementing agreement, of course, has produced numerous regional fisheries management organizations, which are their own agreements and have their own secretariats and member states. And that framework or architecture is continuing to be built out. Of course, the second implementing agreement is establish the International Seabed Authority, and this is with regard to deep seabed minerals. And for the first time in our lifetimes, it looks like the issue of seabed minerals is finally becoming more salient. The reason is because these seabed minerals are far richer on the seabed in terms of concentration than they exist on land. And these include some of the rare earth metals and strategic metals that all of us are interested in for our iPhones, solar panels, and electric vehicles. So this will be becoming more important, I would suggest, in the future. And then finally, there's negotiation ongoing right now for even a third implementing agreement on biodiversity beyond national jurisdiction. The Law of the Sea Convention sought to internalize and protect and conserve marine resources, principally through the continental shelf and the exclusive economic zone. And then those deep seabed mineral resources beyond are under the purview of the International Seabed Authority. But it hasn't done as well with regard to protection of the marine environment beyond national jurisdiction, and so that's what this third implementing agreement will do. And if it comes to pass, and it looks like it's likely to in the coming few years, then this third implementing agreement will also plug into this architecture that's based on the UN Convention on the Law of the Sea. So the Law of the Sea Convention is not just a single treaty, it's really a legal ecosystem for helping to manage the environment, all of our shared interests in the oceans, navigation, and security. Finally, I would say that the Law of the Sea Convention, at the time that it was adopted, was quite revolutionary in that it had mandatory or compulsory dispute resolution procedures. And this means that once you join the treaty, you are obligated or have a duty under almost all circumstances, except for some limitations in Article 297 and optional exceptions in Article 298. Except for those exceptions, states have a duty, a legal obligation, to go through compulsory dispute resolution, which is, of course, exactly what we want to peacefully resolve disputes. And this legal framework for resolving disputes is continuing to advance year by year, further developing through case law the law of the sea. And yes, you might say, a follow-up question might be, yes, but what if states don't comply, as states sometimes don't comply with their legal obligations? Nonetheless, I would say that the convention and this compulsory dispute resolution solidifies at least the normative framework and continues to strengthen the stability of expectations that are so important when we interact in the oceans.
No, absolutely. Thank you so much for that comprehensive answer there. My next question is somewhat closer to home here in Pakistan. We witnessed just last month an Indian submarine intruding into Pakistan's exclusive economic zone. And as you're well aware, this isn't the first time that's happened. In your paper on submarine espionage, which I read a few years ago when I was preparing for a Jessup. I was a judge there. It was a fantastic paper. Really, really enjoyed it. Putting Your Head in the Tiger's Mouth, Submarine Espionage in Territorial Waters. In that you note that it is doubtful whether states may take recourse to forceful action or invoke the doctrine of self-defense against submarine intrusions in territorial waters. Given the state of relations between India and Pakistan and the dangerous potential for escalation, what legal options would a state have against submarines entering their territorial waters?
Thank you for the question. So, the Law of the Sea Convention has different frameworks for states dealing with sovereign immune versus non-sovereign immune vessels that are not in innocent passage. And so, of course, within the territorial sea, vessels of all flag states may exercise their right of innocent passage, and then the question is, what if they are not in innocent passage, such as a submerged submarine? Under Article 25, coastal states can take necessary steps against a vessel that is not in innocent passage. But under Article 30, if that happens to be a warship, such as a submarine, then the standard is that the coastal state can require it to leave. Of course, these are somewhat ambiguous terms, and if you look to state practice, what this means is that states have occasionally signaled to the submarine that they understand that the vessel is there, the ship is not in innocent passage, and at most they've done so through depth charges, which are regarded in the maritime domain in this context as not a use of force, but rather as a signal to the submarine to leave the territorial sea. So I would suggest that this state practice is actually quite useful as a guide going forward, which is that the coastal state has sovereignty over the territorial sea, and we are all interested in de-escalation, and so I think it's appropriate in requiring it to leave that this is does not create a direct incident or a use of force. I think that all states have an interest in de-escalating these situations. On the other hand, sending a signal that the submarine is unlawfully present, I think, is useful. That I would distinguish from what you started your question with, which is the exclusive economic zone. And recall that the EEZs comprise some 38 or 40% of the world's oceans. And the EEZ, unlike the territorial sea, which inures to the coastal state, the EEZ actually was cut out of the high seas. And in the Law of the Sea Convention, in the negotiations in the Third UN Conference, the international community ceded part of the regulatory competence over the high seas to the coastal state. That is, the EEZ was never, until it was negotiated, never part of the coastal state. It was the international community that allowed coastal states to internalize, in a limited area of living and non-living resources, internalize and exercise state competence over those resources. But all the other balance of rights, including freedom of navigation, were retained by the international community. So this is a position of a majority of states, a great majority of states. It was also the understanding of Ambassador Tommy Koh, who was president at the Third UN Conference. And I think that it's the best approach in order to maximize all users' use and enjoyment of the oceans. Now, that doesn't mean that it's the Wild West, because of course the operation of warships, even in the EEZ, as well as on the high seas, are still governed by the principal rules that we have in the UN Charter, including the obligation not to effect the threat or use of force against another country. Thanks.
Thank you very much, Professor Kraska. I wanted to now move on to Mr. Landau. And this is a very broad question. so you forgive me for asking it like this, but the international investment regime, how do you locate it, or you know, the bilateral investment treaty regime, how would you locate it in a discussion on global security?
Thank you very much for the question. Assalamu alaikum. Very, very great pleasure to be here. We shift now to international investment law and arbitration. And so the question, I suppose, is, after everything you've heard so far, how does this fit in? And the fact is, it fits in as being a fundamental element in maintaining security, because it is part of the international rule of law. And what we're talking about is the protection of foreign direct investment. That is an area of law in which Pakistan has played a very active role. It is made up of a web of international so-called investment treaties, normally bilateral investment treaties, but also chapters of free trade agreements. And what these agreements do is they set out substantive standards of protection in order to attract foreign investment into a host country. The first one was concluded by Pakistan with Germany in 1959. Pakistan's had a long history with these treaties. It now has probably around 60 or so. I'll be corrected. It's around about that number. Now, as well as including substantive standards of protection, many, perhaps most of these treaties also include an international dispute resolution provision or arbitration clause. And that's pretty unique, because what it means is an individual investor, not naming any particular names, but such as Recodig, or Kaki, or SGS, or Improgilo, or Bayinda, all the ones who have come to Pakistan, if they have a complaint against the government, they can bring that complaint at the international law plane directly against the state under the treaty. So, in terms of security, this is it's incredibly important for Pakistan to understand its relationship with this web of norms, this network of treaties. Apart from anything else, Pakistan, as it has found, may well be the subject of massive claims. And that, in turn, may lead to economic insecurity. And if I can just take us back to this morning's comments by General Bajwa, General Bajwa made clear that it is Pakistan's policy to attract foreign investment and to increase economic security. That cannot be done without Pakistan first establishing its understanding and relationship with this network of treaties. Just very, very briefly, if you allow me one more point.
Absolutely.
This is controversial. It's highly criticized. Arbitration was unknown amongst many people until recently. You can now get in a rickshaw in Lahore and the driver will ask you about Recodig. Everybody's talking about it, but not necessarily understanding it. So one point to bear in mind is that whether we like this system or not, it is there as a better system to what was there before, which was no international regulatory system to protect foreign investment, and the dangers then of diplomatic protection. That is, foreign investors who get hurt by a host country seeking recourse through their country's government. And that used to, in the rich, wonderful old days, would lead to gunboat diplomacy, because there was nothing to focus a mind better than blockading a port. We've moved on from that, happily.
Absolutely. No, thank you so much for explaining that. I think that's something that is really important for us to understand how this entire discussion fits into the global security discussion. There is something that I think in Pakistan many people have in their mind, and that's that over the past several years we've heard numerous arguments that the international investment regime is lopsided, is that it favors investors to the detriment of developing nations. How far do you think that this assessment is correct, and where do you think we go from here? Are we is this the beginning of the end for BITs?
So this is a very commonly asked question. And there are 2 points I'll make initially. The first one is, and I'm going to make this point, if you forgive me for a little brief CV reference. I'm going to make this point as somebody who's practiced in investor-state arbitration as counsel and arbitrator for about 30 years. And I have sat on, as arbitrator, probably about 40 international investor-state cases. The first point I will make is, it is simply incorrect It is wrong that the system is lopsided, that it is actually stacked against developing countries. My second point is, my first point is now irrelevant, because the general perception is of mistrust, that the process lacks legitimacy, that countries are getting hurt by it, and that reform is needed. Many countries, Pakistan included, are now formulating policies to terminate their bilateral investment treaties, to walk away from the system. This leads on to a very, very important analysis, which, if I may say, is hardly ever looked at. It's hardly ever articulated. It is a grave error to assess the process from simply the perspective of arbitration cases, actual disputes. People win and lose disputes, like you win or lose litigation in court. It is an inherently uncertain process to litigate. I don't tell my clients that, but it is. It depends on variables, how good the judges are, how good your lawyers are, how good your facts are. You can't simplify this to say, well, we are losing arbitrations and therefore it's a bad system stacked against developing countries. That is not true, and Pakistan's track record shows it. Pakistan has had great success in investor-state arbitration. In SGS Pakistan, it did well. In Improgilo, it did well. In Bayinda, it did well. There are many others. The two that have now become prominent are Karki and Rekodik. But where the mistake comes is to think of it just as a litigation process. Actually, the answer is not simply, let's just get rid of these treaties. Apart from anything else, you can't get rid of them straight away. A lot of them have sunset clauses that mean even if you terminate them now, you're going to have to live with them for another 10 years or so. The answer is not just try to renegotiate your treaties, because you may or may not be able to renegotiate the treaties. That is aspirational, depends on what you can agree with other countries. The answer rather is something quite different and quite simple. The problem with investor-state treaties is there is a gulf between the standards that are agreed to in the treaty and the ability of the country as a matter of governance to meet those standards. That is the simple equation. And critically, if there's nothing else you remember from what I say, please remember this. This is not a problem about less developed countries. It's a problem for every country. Let me give an example. In Rekodik, not to specify a particular case, there was a problem about the governance policy, the activity, the conduct of a provincial government, Balochistan. Whatever Balochistan did, the central federal government is going to be responsible, the country is responsible, as a matter of the law of international responsibility. To what extent can Islamabad regulate what's happening in Balochistan? That's not a less developed country problem. The same problems happened in Canada. Canada has federal government and provincial government. In fact, it has, many people say, many Canadians, too much government. It's got government at every level. So to what extent can the top government, who's then going to pick up the pieces in an arbitration, regulate what's happening lower down? So what we actually have to focus on is how do we bridge this gulf between what has already been agreed to in a network of treaties and how do you govern in accordance with it. And that is where Pakistan needs to learn from other countries that are beginning to wake up to this. What they're actually doing is building in international law consultants and advice at the moment when policy is being formulated. That's not at the moment when you get a claim and you have to go to arbitration. It's too late. It's actually at the moment when you are deciding on how to regulate yourself in a way that may impact adversely on foreign investors. Other countries now do this as a matter of course. One country is an unfair comparison for all other countries because it's small and super efficient. It's Singapore. I regularly give advice to the Singapore government on policy they're thinking about way earlier in the process. So for a country like Pakistan, this is not impossible. It just means actually elevating this issue, understanding the issue earlier on, building up local capacity, which is critical. There are any number of people out there, many people in this audience, who are already highly skilled in this area or would like to be skilled and to learn. And Pakistan has a lot of goodwill internationally amongst the international law professional community for assistance. It just needs to call on it and start to reintegrate. So my final concluding message, having spoken for much longer than I intended, is the mistake is for Pakistan to turn away from this. The answer is for Pakistan to move and integrate into it and become proactive and shape it. And that is actually going to be fundamental for future security.
Thank you very much for that. I want to thank Mr. Ahmed Irfan and come to him now for his patience. There's a reason I had you at the end, and that's because, one, you're the only Pakistani on the panel, and I wanted to ask you something. I know many here want to hear about your experience in Reykjavik and the efforts you're doing in a lot of the arbitrations there, but I want to look at something else slightly. Today, the international rules-based system that we recognize is really, post-Second World War. So we have about 70 years of experience looking at the efficacy of this system and being able to judge it on whether it, plays the role that the world needs it to play now. My question to you is that as a Pakistani, as a citizen of a developing country representing, say, the global south in this, how do you view the international rules-based order, and do you feel it's responsive to the needs of the global south?
Thank you very much. Let me start by thanking NST for hosting this and for inviting me. I think it's oversimplistic to paint the entire international law system with one broad brush and to think that everything could be seen through one lens. It's a complex system that has evolved over 7 decades, more than 7 decades, to address common problems that ranged from war and peace issues to address and to promote common goods like emergence of technology, to addressing emerging challenges that emerge from technology, such as environmental catastrophes. In doing all this, the international system has provided us with common standards. Those common standards have, to a very large extent, been applied consistently, and that has served as an impetus, and it has provided us in a context in which domestic reform can happen. If you look at overwhelming legislation done in Pakistan over the last, say, 4 decades or so, you would see that overwhelming majority of it was inspired because of international obligations. So international system has inspired domestic reform. Wherever reform was difficult or impossible, international obligations made it happen. And to a very large extent, it has worked for Pakistan. A great part of my career was spent in the UN system, and that allowed me to travel through the length and breadth of Africa. And I saw one thing that was common, that wherever countries were able to reform their domestic systems in a manner that wedded domestic considerations with international obligations, the reform worked for them. Countries like Ghana and Ethiopia have grown tremendously because they were able to wed and find that happy balance between international obligations and their domestic considerations. If you look at closer to home, regionally, Bangladesh is a perfect example. They were able to do that rather successfully, not in the realm of environment, I dare say, but in many other things they were able to happily wed that. The other aspect of this thing is, and since Mr. Landau mentioned investment arbitration, is to see how Pakistan has fared in international dispute litigation system. Again, I think it would be overly simplistic to say, to look at every organization and to every dispute through one lens. The system depends on the design of the organization, The design of the organization in turn affects the culture of that organization, and the culture of that organization in turn affects the outcome of disputes. Just to give you an example, investment and trade are very similarly connected. But WTO and ICSID cannot be more different in the design, in the way system is designed. WTO has a permanent secretariat, a permanent dispute settlement body. ICSID has no permanent dispute settlement system. It has ad hoc dispute settlement mechanism. A permanent secretariat allows access to negotiating history, negotiating documents, the travaux. In the ICSID investment arbitration system, there's no access to, and it's not always possible for arbitrators to understand and appreciate the carefully negotiated political compromises that were made as part of the negotiating process. And that results in the outcome of disputes. Just to give you a small example, in an investment arbitration system, the fair and equitable treatment provision claim is successful very often. But the equivalent provision in the WTO system, which is GATT Article 10, almost never succeeds. Almost never. Even though they're very similar in their legal construct.
Absolutely.
And so, on the whole, it would be, I think the system has worked for Pakistan. We have done very well. If you look at the overall history of all the disputes across organizations, across treaties that we have had, we've had a stellar record. And I know it is, and this might come as a surprise to a lot of those who are in the room, the general perception is that we're losing. Reality is the exact opposite. We almost never lose. So the system as a whole has worked wonderfully. Now, does it address every problem? No. Is the system perfect? No. Just to give you an example, and Kashmir is very complex and complicated, so I would not touch it. But the other example is, you take the Indus Waters dispute. It has been almost 6 years since Pakistan's request for establishment of the Court of Arbitration, but the court has not been set up. Why? Because politics gets in the way. And as a colleague said, that international law is a horizontal system where theoretically all states are equal, but in reality some are more equal than others. And so in that sense there is a degree of dissatisfaction. But on the whole, the system has worked wonderfully for us. Thank you.
Thank you so very much for that. There is another question, and I alluded to this very briefly in my opening, and that's about Pakistan's role in shaping international law. I think the small international community that we have here, we continuously bemoan the lack of capacity, or the fact that we haven't been very prominent when it comes to, say, treaty negotiations. How do you feel we can address that domestically?
I certainly agree with you that there is a lack of capacity, but what is also a painful fact that the overall threshold of capacity has lowered over the last, say, 3 decades or so. It has lowered for 3 reasons, in my view. One, we stopped investing in education, in legal education, and international law is never a subject of choice for young budding lawyers in Pakistan. As you've taught international law, and you'd see that international law classes has about 6 students, even at the best of universities. And even those students see it as a minor subject, as not a major subject in which they need to invest in. Second reason has been, at a governmental level, we stopped investing in building organizational or institutional arrangement that would deal with treaty negotiation and dispute settlement at the same time. The Foreign Office the Office of the Legal Advisor at the Foreign Office, till about 2 decades ago, used to have a number of lawyers who would work and advise constantly on treaty negotiation. If you look at that, till about a few years ago, there was nobody there, and now they've started repopulating that. There was no institutional mechanism till about 6-7 years ago to deal with international disputes. And so the institutional arrangement has suffered, and that needs to be invested in. And the third reason why capacity has gone down over the years is because subject matter has become increasingly complex. It is easy to understand broad international law principles when you're debating war and peace issues, or things like when armed diplomats negotiated Vienna Convention, for example, on diplomatic relations or on consular relations. There were easier concepts to grasp. When you start talking about satellites, my mind certainly switches off, and every time I'm presented with a text, I have to turn to an engineer to understand what it's all about. Quite recently, I was dealing with an assignment to deal with ITU, and it was all Latin to me, and I had to talk to an engineer to translate it into. So the subject matter has become so complex that I think the institutional arrangement for treaty negotiations, so that we can actively participate, is to house experts in each individual ministry who can then support the Foreign Office in building and negotiating a negotiating strategy and developing a position. From our negotiation abilities in the 1960s and 70s, when we were proactive, if you look at us now, we are largely reactive. We are reacting to situations.
Absolutely.
And unless it is fixed, I fear that we would be relegated to the margins of the rulemaking system. The fact of the rulemaking system is that it is done to a very large extent in small groups. In New York, there is this thing called the Breakfast Club. In Geneva, there used to be the Green Room, when Pascal Lamy was the Director General. And in these rooms, in these clubs, only those countries are typically invited, those who are contributing positively to something. If you don't have the capacity, you don't get invited to these things. And if you don't get invited, you naturally become reactive to lawmaking proposals.
Absolutely.
And I think there's a dire need to invest in these things.
Absolutely. Thank you very much. Ladies and gentlemen, that concludes this session. That concludes this part of the session. I would now like to take the next 15, 20 minutes. We did start late, and I assured the organizers, in fact, I made no commitment whatsoever that I would finish on time. So we have a good 15, 20 minutes now. So I'll take field questions. The gentleman in the front. Can we get him a mic?
Assalamu alaikum. Hi, I am Zohaib Babar, a student of Strategic and Nuclear Studies at Quaid-e-Azam University, Islamabad. Sir, I have two questions. My first question is, do you think there is a need of amendment in international humanitarian law and IL according to modern non-kinetic and cyber warfare? My second question is...
Sorry, could you repeat the first question a little slowly, please?
Yes, why not? Do you think there is a need of amendment in IHL and IL according to modern non-kinetic cyber warfare? My second question is, why UN clause is failed to resolve ongoing crisis in South China Sea? Thank you very much.
So I believe we have one question to Dr. Maciek and one to Professor Kraska on plus. Please.
So if I understood correctly, the question was whether there is a need for an amendment in international humanitarian law to address the effects of non-kinetic warfare. That's right? I think it brings us back to what I was discussing in the presentation earlier on. what we need to understand first is how the rules that we have are interpreted by states. And so when you talk about, you know, non-kinetic effects of cyber warfare, so one example relates to the notion of attack that I didn't go into much detail. So there the question is whether cyber operations that result in the loss of functionality, so that's a non-kinetic effect, right? You have a network on the other end. The example that I used is a banking network. There is an important reason why I use that example, because if you think of, for example, a water purification plant, that under IHL terms would qualify as an object indispensable to the survival of the civilian population that's subject to an elevated protection under IHL. The same for medical facilities, the same for networks that might belong to impartial humanitarian organizations. They are subject to a higher protection, and we could make a good argument that they are protected sufficiently under the existing law, because simply interference with such networks would violate the relevant rules. So for example, with objects indispensable, if you render useless a water drinking facility, that's prohibited by the relevant conventional but also customary prohibitions of IHL. But now, the question is, what do we do with cyber operations in general? There it depends on the interpretation of the notion of attack. Now, under IHL, we have a definition of the notion of attack. It's found in Article 49 of the first additional protocol to the Geneva Conventions. Now, I should say a word about the first additional protocol because it's a treaty that's widely ratified, but it's not ratified by all countries. And of course, Pakistan is one of the countries that have signed but not ratified the treaty. But when it comes to certain provisions in AP1, in the first additional protocol, they have acquired customary international law force over time. And I think almost no one would dispute that Article 49 is one of these customary provisions. And so the definition of attack that's found in Article 49, in other words, an attack is an act of violence against the adversary, whether in offense or in defense, is something that we all agree on. Now, sorry. So, okay, so I saw another hand in the audience. Okay, so now with this definition, the question then depends, how do we interpret the act of violence when it comes to non-kinetic effects? And we have more or less two schools of thought. One is a narrow school of thought and one is a broader school of thought. Under the narrow school of thought, what we need to have is either injury or death to humans or physical damage to objects. So under this interpretation, the example that we're discussing, when you have non-kinetic effects on a banking network, would not be covered by the relevant rules. So this creates what I referred to earlier on, another protection gap. However, there is also the broader approach. It's the approach that the ICRC takes as well, which is that it's not only those operations that result in physical damage, but also those that result in any kind of disabling of the infrastructure in question would be covered under the notion of attack. So if you want to find more details about the legal reasoning on that, you can find it in the position paper that I mentioned. But I'll just mention one reason why I'll have the floor. And to me, that's the most convincing one. And it goes to the object and purpose of the rules in question. So, we lawyers, we think of teleological interpretation. We look at what is the goal of the rules in question. And the goal is to protect civilians. It's in the name of the treaty. It's the additional protocol for the protection of victims of international armed conflict. So victims are civilians. So when we have two interpretations, they're both reasonable and they're taken by different states. But under one of them, you protect civilians from the grave effects of potential cyber operations during armed conflicts. And taking down a banking network abroad creates graver humanitarian consequences than bombing a branch of that bank, which certainly would be covered by the rules. So I think when you look at the object and purpose rules of the rules, to me it's a very compelling reason to include the non-kinetic effects. I hope that answers your question.
Thank you. Professor Kraska, I believe the question was on dispute resolution under UNCLOS.
Thank you for the question. So, as I understand the question, it's about if the law of the sea is effective, then why has it failed in the questioner's term to resolve the South China Sea dispute? And what I would suggest is that the law has not failed. The law is just one element of international relations, interstate actions, and you can't expect the law to do everything or solve all of your problems. So this is one of the features of international law generally, which is that it lacks an there is no international legislature. There's not a global legislature. There's the UN General Assembly that doesn't have much jurisdiction outside of its own budget. There's the UN Security Council, which of course has its own problems with coming to agreement, and it rarely has come to agreement on compelling states to comply with international law. And there's not an international judiciary in the sense that there is in all of our countries, because for the most part, states must consent to be bound by judicial decisions. Now, in the law of the sea, when you join the convention, you agree to be bound, and therefore there is a legal resolution in the South China Sea dispute. There was a unanimous decision by an Annex 7 arbitration, and China has ignored to implement those final and binding decisions. So where does that leave us? Well, it's a question of whether the glass is half full or half empty. I'd like to say that it's half full. You have a number of states since 2016 and the decision that have recognized and called upon China to comply with the decision. Of course, China is a sovereign state, and there's not any mechanism to compel a state in this type of case. And yet, the decision is not going away. It has great normative force and normative effect, and states suffer a diplomatic cost and a reputational cost when they do not comply with those decisions. And that's true, for example, with the United States and the Nicaragua decision, in which the United States did not comply with the paramilitary activities case. And over the ensuing decades, that has led to some disassociation between the United States and other countries on jus ad bellum and the use of force. So I would suggest that China is experiencing a similar cost, and what we're hoping is that the normative effect of these decisions continues to grow and make it less likely that states do not comply with their international obligations.
Thank you very much, Professor Kreska. Could we get a mic to Javed Jabbar Saab? He has a question.
Thank you, moderator. In fact, I'd like to begin by complimenting you as a moderator.
Thank you very much, sir.
Asking extremely thoughtful and provocative questions, very gently provocative.
Thank you.
But each of the panelists really has helped us become so much more informative and educated on this subject. Thank you. My question is for Professor Hurst Hannum. And I know you probably meant well, but in your very lucid reflections on the principle of self-determination and its legal enforcement, I thought you equated the positions taken by Pakistan and India by saying that both countries look at this as a territorial issue of possession. If I'm mistaken, please correct me. But there is a fundamental difference between the way India articulates its position and the way Pakistan does. Pakistan has always enunciated the principle of self-determination, not a question of territorial possession. That is just political rhetoric at times, but its legal diplomatic position is rooted in the principle of self-determination. In stark contrast to the Indian position, which has arbitrarily attempted to annex and integrate the Indian occupied part of Kashmir and give it constitutional legitimacy. In our case, our part of Kashmir is not part of the state of Pakistan. It is still today in 2022, it has its own constitution and its own status. Of course, there is tremendous influence by Pakistan. So I just would appreciate your comment on that. Thank you.
Professor Hannum? So we can't hear you. I don't know if it's you're muted or
yes.
not. Yeah.
Thank you very much. I knew if I even mentioned anything about Kashmir that I would get at least one question. And I'm more than happy to accept your clarification about the differences in approach between India and Pakistan to this question. I suppose I linked the two countries, perhaps unfortunately, because I have been involved in the Kashmir situation to some extent through the Kashmir Study Group, a non-profit group in the U.S. that did some work to try to mitigate the conflict. And at about the same time, I was also asked by the United Nations to serve as legal counsel to former U.S. Secretary of State James Baker as he was trying to come up with a new peace plan for Western Sahara. And the difference, I suppose, between the two cases is what struck me more than the similarities, and that was that in the case of Western Sahara, clearly a colony that clearly had the right to self-determination, i.e. independence. This was an issue with which we began our discussions and was one reason that the Moroccan government ultimately did not accept the proposal made by Secretary Baker, because it did include at least the possibility of independence. In dealing with the situation in Kashmir, and most of the attempts were to change the behavior or bring the Indian government into the discussion as opposed to anything else, we didn't talk about independence. Kashmir simply doesn't fit the classic limited nature of self-determination as a former European colony that had the right to become independent. I don't recall, and I could be mistaken, the Pakistan government ever supporting the idea that Kashmir might be independent. Obviously, the Indian government has not done so. And I suppose it's one reason why the conclusion of my brief remarks was simply that self-determination, while it's a wonderful term, very rarely helps us get closer to a possible and pragmatic solution to very serious problems in the world. It's a wonderful concept. It doesn't mean what most people think that it means, and because of that, I think it's frankly caused more problems than it has offered solutions. I hope this helps somewhat, but I certainly didn't mean to equate the two countries entirely.
Thank you so much, Professor Hannam. I'm extremely grateful to His Excellency Judge Raul Pangalangan for staying with us throughout this. Judge Pangalangan, would you have any closing comments since you've heard the entire debate? I hate to be putting you on the spot like this, but...
Well, indeed you have. I just want to thank the panelists for the insights that they shared with us this morning for my time zone. I think really the theme of the session calls upon all of us to find ways to define the role of international law vis-a-vis the disputes that we face today. And it is in fact the challenge to the discipline on whether it wants to respond that quickly to the demands of history while perhaps weakening the norms of the discipline, or upholding the norms and asking history to be a bit more patient. But thank you for giving me this chance.
Thank you so very much, sir. I would also like to thank now our speakers, Professor Hannam, Professor Kraska, Dr. Azaria, Dr. Machik, Mr. Toby Landau, and of course Ahmed Irfan Saab. Thank you so much for taking the time out. Thank you to the audience for being with us. That concludes our session. Thank you very much.